Welcome to Clause 8, presented by TradeSpace, where the voices of IP come together to talk about the forces shaping the industry today. If you enjoy this show, please take a minute to subscribe on clause8podcast.com for any updates and wherever else you might listen to podcasts. While you're at it, don't forget to leave us a 5-star review. It really goes a long way. Today, we're doing something a little bit different. We're joined by two returning guests for the first ever Clause 8 debate. The subject, Section 101, Patent Eligibility. First up, David Jones, Executive Director of HTIA, which advocates for some of the largest tech companies in the world. And for the other side, we have Andrei Iancu, who implemented the 2019 revised patent eligibility guidance when he was the USPTO Director. Andrei and Dave debate the state of patent eligibility in America.
Patents are not just any other area of law. Patents are effectively, they're legal instruments, of course, but they're also commercial instruments. All sorts of huge, sometimes super consequential decisions are made based on patent rights. And in the business world, you definitely need a lot of predictability.
They also discuss possible paths forward and find a surprising amount of common ground.
If we can make the law clearer, clearer law is always better, period.
And now, here's your host, Eli Mauser.
I'm just going to actually just thank Dave for bringing up the idea of this Clause 8 debates. And when he said that, the first thing that came to mind is I need to have him and former director Andrei
Just to be
Iancu
clear, I was not volunteer. I was as a listener.
No, he was not.
I said I thought that would be interesting. So
no, it's usually very hard to convince Dave to do this, but for me, he's gracious enough to do this, and he's a recurring character on the Clause 8 podcast. As obviously, Director Iancu is a returning guest as well, and he's been mentioned here a lot as well.
I do like the fact that I'm a guest and he's a character, but that's a good way to start, Eli.
I think that's accurate, though, isn't it, Andrei? I am a character. And I should ask, are we going with director or Andrei? What's the protocol?
Andrei's just fine.
All right, so we're going to be discussing Section 101 and patent eligibility. My wife usually doesn't like to discuss patent stuff with me, but yesterday she was talking about, she works for a fintech company, and we started talking about what you can get a patent for. And I was explaining to her, novel, non-obvious, that's pretty simple to explain. And then I came to patent eligibility. I've been doing this for a while, and I couldn't give her quite an answer. And then she said, well, we come up with technical solutions for non-technical problems. Why can't you get a patent on this? Dave, maybe we can start with you. Do you think you should be able to get a patent for a technical solution to a non-technical problem?
Way to start with a loaded question, a hard one. I think generally not, but a lot of it depends on how you define technical. And I think it shifts over time. For example, in Europe, linguistics has historically been considered non-technical. Does that mean that large language models should not be patent eligible? I think probably not. I can't give you, unfortunately, a clear answer. I'd be somewhere in the middle. I think it would be something case by case.
So let me, I guess, give a more concrete example then. If somebody comes up with a new box, it's novel, non-obvious, they'll be able to, it's patent eligible to get a patent. If some mathematician comes up with a new trading algorithm to make the markets more efficient or a new financial instrument, at least without very clever patent attorneys, the way it stands, they can't now. Why should there be a distinction? Why can you get a patent on a box but not on these other types
So as you know, I have a
innovations?
very dim view of business method patents. So yes, I would not favor patents on something like that. I mean, part of it is empirical and part of it's traditional, historical. So the history of the patent system is that non-technical innovations have been left to other forms of IP. And you see that in pretty much every patent system in the world. That has been the tradition. But there are also kind of empirical examples. I mean, you look at some of the early work on business methods, and business methods were asserted something like 27 times more likely to be asserted in litigation, right? And there's also a fair amount of evidence, again, from kind of economic literature, that if you are inventing in an area where it is not capital intensive, where you don't have to buy very expensive equipment or build a factory or do all these different things that you usually do for physical experimentation, the patent system doesn't seem to add a whole lot. And my favorite paper on this is one that looked at what companies that had been getting business methods prior to Alice did post Alice, and actually found that they increased their spend on R&D. There have been some economists in the past that have posited this idea that maybe patents in these areas that are not capital-intensive research, maybe they serve more as hedges against competition, and in that way they would be a substitute for innovation, which is the exact opposite of what we want. And that paper, at least to me, and it was a very small sample size, I don't know if it holds generally, but it seemed to indicate that may be the case, that actually if what we want is technical R&D, the last thing we would want to do is grant business method patents because it seems to potentially deter people from kind of full investment.
Andrei, does that convince you? Were the law is a positive because it encourages more R&D?
Well, I generally agree with the principle that they've outlined, but not necessarily the reasoning. But let's just step back a little bit, going back to the foundation of the American patent system and the Constitution. From the get-go, what the framers put in the Constitution was the concept of a patent for the useful arts. Okay, and it wasn't for the fine arts, for example. It was not for the business arts. And the useful arts had a meaning, an original meaning, during constitutional times. And then that translated into the patent code from the very beginning, right? Section 101 actually almost word for word dates back to the Patent Act of 1793. And, the word useful appears in there. So we historically, at least in the United States, have always focused on the concept of useful arts. Now, we have to determine what that means, and I can come back to that. But then you look at countries around the world, almost every country agrees. You look at the European Patent Code and look at Article 52 in the European Patent Code. There they talk about the concept has to be susceptible to industrial application. The same general idea. It has to be technological. It has to be industrial, useful arts, that general concept. So we're not giving patents to painting, choreography, songs, movies, literature, or business transactions. Historically, it hasn't happened. Now, the question gets more difficult when you ask it the way you did, Eli, which is, what if you have a patent on a mixed set of innovations? So the way you asked it, I think, is a technical solution to potentially a non-technical problem. At that point, you might have a useful arts application that is in a different world. For example, in the art world, you could have a useful arts application, a technological application in the movies, or in song processing, or what we're doing here today in recording sound. You likewise could have a technical solution to a financial transaction, right, where you're applying very complex computing technologies, for example, with specialized processors and whatnot, that everybody would recognize as technological, useful, industrial, etc., but the application for it is in a non-technological environment. That's where it gets more difficult, and a lot of the problems the courts are having is at this confluence of technology and non-technology, and there has to be a mechanism to resolve that confluence.
There was the State Street decision back in 1998. The Federal Circuit decided, and the interpretation was that business method patents are patent eligible. Some people have called it the golden age of business method patents. Where the law was at that point, was it a positive or negative for the patent system and for America?
Well, look, overall, on balance, you look back, it turned out to be a negative, I think, because it opened the era of confusion and uncertainty as to how to treat these patents at this juncture between technology and non-technology. But let's make it clear, some things are not that difficult, okay? If you have a pure business method, could be incredibly innovative, but there's no technology involved there in solving it, for example. I think there's broad consensus that is not the useful arts. Same with mathematics. The example I very often give is the invention of calculus, okay? Newton, Leipzig, whoever is deemed to have invented calculus. It's absolutely brilliant, right? It's clearly recognizable as a huge innovative step for humanity. I think there's broad consensus that there should be no patents on calculus if that were invented today. So the same thing with pure phenomena of nature, gravity, right? Again, Newton sits under the apple tree, apple falls on his head, says, aha, there's gravity here. Humongously important discovery, and I think, again, broad consensus that it should not be patent eligible. I think that's also generally true for pure business methods. A brand new method of hedging transactions, to use a random example, or of a brand new method for transferring money between escrow accounts and whatnot, which there's no real technology involved there. But it could be super innovative from a business perspective. Again, I think, not everybody agrees, but I generally think there's broad consensus that those should not be eligible. Again, the difficulty comes when you add to any one of these, math, natural phenomena, business methods, when you add to one of these some technology to solve or create something new.
And Andrei, correct me if I'm wrong, but I'm hearing if it's useful and technological, it should be patent eligible.
When there's this confluence between technology and non-technology, you have to look carefully at the claim. But as a general principle, if you have something that's clearly in the useful arts, it should definitely be patentable.
Does that sound good to you?
This is an area where, surprisingly, I think we're not in complete agreement. Heaven forbid we be in complete agreement. But I think we actually agree quite a bit on this. I think, for me, part of this comes from having worked in a dozen or more different countries on patent eligibility and seeing how these different systems were constructed, and also looking at the history, which is pretty clear. To me, one of the easiest ways of conceptualizing this, and there's not going to be any definition that's perfect, but the useful arts really used to draw a distinction between the sciences and fine arts and engineering and practical arts, right? So it's the sciences versus the applied sciences. And I think when you think about it that way, it's not only is it intuitive for most people, like most people will be able to look at something and say, yes, that's technological, no, that's not technological, but it makes sense and it matches us up with the rest of the world. And it matches up with what has worked historically pretty well.
After State Street, it seemed like this law was settled for about 15 years, I guess, if you weren't paying attention to the complaints in D.C. And then we had a series of decisions, Bilski, Mayo, Myriad, and Alice. And I think it was interesting because if somebody just Googled your views online about what are your views at the time, they might think your views have switched. Andrei, after I think the Myriad decision, correct me if I'm wrong, you were involved in the Ariosa versus Sequenom case, which dealt with fetal diagnostics, and that was found not patent eligible. Like, when those cases were happening, were you worried? Were you saying, actually, they're getting things under control?
Yeah, look, I don't think my views have really radically changed in any way. And just keep in mind, I was representing a client. Yeah. So the views expressed there were the client's views, and by definition were the correct views.
Did you feel their pain, like the client's pain that they had to deal with this kind of
Let's just talk again, basic principles. If it's a pure discovery of nature, okay, you're observing nature. Again, Newton observes gravity. Or simply have the scientific discovery that there is fetal DNA in the mother's bloodstream. You just simply observe that discovery of nature. Things like that. I think there's broad consensus that we're not giving patents to that, right? It's not the useful arts. It's not practical, as they've indicated. So now, again, pure observation that there is fetal DNA in the mother's bloodstream, like other observations, not patent eligible in my mind. It gets more difficult if you're using technology to make that observation. The question then becomes, in that patent that you mentioned in that case or other cases, was the use of technology there meaningful enough and itself new, non-obvious, etc., to qualify for a patent? And I do encourage people, if they still have questions about that case, to look at that patent and the claims in that patent and make a decision for yourself. In that particular example, is there technology there that is sufficient enough for patentability? As long as you accept that the observation of nature itself is not eligible. It's a difficult case because you have this confluence. But if, what the court decided there was that no, not sufficient technology. It's mostly the observation of the pure science that fetal DNA exists in the mother's blood.
So around the time when that string of cases came out, you were at Microsoft. After the Alice came out, I think there was some concern about, Alice just wiping out all these software patents. I think you eventually decided that it wasn't as bad as many
Not
feared.
bad at all. It might be good.
But can you share your thinking? Why were you concerned after
It's funny,
Alice came
if
out?
you dig around the internet, which I know Eli does periodically, you can probably find a video of me. I think I was at a conference. It may have been the Fordham conference, the day that Mayo came down. And I went onto this panel with my hair on fire saying, if this is applied to software patents, there will be no software patents. It's the end of the world. The sky is falling. It's the worst thing ever. And then I think I spoke at some PTO roundtable where I incidentally hadn't slept for 2 days. So I was barely coherent. But
that's your excuse?
Well, I'm barely coherent ever, Andrei, as you know. But some days are better than others. Where I said we looked at our portfolio, we thought, maybe 80% of the portfolio disappears. And there are reasons that we had that concern. There is a strain of thought, and you can, if you look at the software patent debates in Europe and in New Zealand, for example, and several other countries, you'll see this, where people say, well, software itself is inherently non-technical. And if you come at the problem saying software is non-technological, non-technical, well, the addition of a general-purpose computer, which is what software runs on, doesn't make it any better, then you could have an Alice-like or a Mayo-like decision that did wipe out vast swaths of software patents, and that would be very concerning. And what flipped me around was really the data started rolling in, right? We were still able to assert our patents effectively. We were still licensing for money, for good value in some cases, effectively. And we started out, one of my jobs was looking at the detailed PTO data. And so we, at some point, purchased something like 5 years of every office action, pretty much comprehensive PTO data. And I was tracking by art unit what was happening with our portfolio and with other people's portfolios. And I realized at some point that in almost every art area we were patenting heavily, our allowances had gone up. And 101 rejections were equivalent to or lower than they had been pre-Alice. And I talked to our prosecutors, and they said not always, but usually you can get a 101 rejection. You can get around it, right? If you come back and offer to, make the claim a little more detailed, add a few things, as long as it's supported by the spec, you're going to get your claims. You're going to get your patent. And, a series of experiences like that kind of convinced me in the end that this is not a huge deal.
Andrei, you had a first-hand look at what was happening at the PTO during that time. Do you agree with David's
We have now come
assessments?
to the natural landing point where we don't agree. First of all, I don't think Alice, the Supreme Court decision in Alice, is a pronouncement on software patents per se. The claim at issue in Alice was on a business method, an escrow account, and having an escrow transaction, which humans do for a very long time in the business world. And the idea was just use a general-purpose computer or computer system to do that escrow transaction. And that, in my mind, is what the Supreme Court reacted negatively to. And in the grand scheme of things, I think if the lower courts would have held to that interpretation of what the Supreme Court did, and if they kept their decisions narrowly focused on business methods of that type, I don't think we would be where we are now. So far, as in what I've said, I think Dave would agree with me to a large extent. Where I think we disagree is where you don't think that the sky is falling. When it comes to 101, right now, the state of the world as is in the United States now, I do think the sky is falling. Funnily enough, not because of Alice per se, but because of the way the lower courts have interpreted that decision and applied it to much more than just business methods. That's the problem that we find ourselves in now. There is confusion as to whether a particular patent claim or technology is within or is not within Section 101 only because of how the courts have been interpreting the Alice decision.
And I should probably make clear, when I say the sky isn't falling, I have a narrow perspective on the world. I have no idea if the sky, I don't even know what the sky looks like on the life sciences side. That is not anything I've ever done. So maybe the sky is falling over there. When I say the sky's not falling in tech, the areas of tech that I've been working in for, I don't know, a couple of decades now, it really doesn't seem to be a practical problem. But I try to be careful. I mean, for example, when I talk to people in the diagnostics field, it does sound like it's very difficult to get patent protection. And there's a big debate. You know, I have doctors and medical specialists who say, well, that's a good thing. That means more tests are available. And I have companies tell me it's disastrous. But what's clear is it's very hard to secure patent protection. And really, it's business methods and those diagnostics are the two kind of reasonably broad swaths of subject matter area where it really is, if you look at the data, it really is just difficult to get patents. And I tend to believe that with respect to business methods, I think Andrei and I mostly agree, that's probably not a bad thing. With respect to some of the stuff in the life sciences, I just don't know.
I think some of the problem does come from what I said is the lower court's interpretation of Alice, but a lot of the problem also comes from the general national disagreement as to whether software is technology. And you know, software has had a love-hate relationship with the patent world from the very beginning, 60, 70 years ago when it came onto the scene. It never found a happy place in the world of IP. It does get some copyright protection, but it's really not the fine arts. It gets some patent protection, but software by itself doesn't actually do anything. It doesn't move the world. It doesn't change the world in any practical, useful sense as people are used to by itself. So you can see how people have some discomfort with software being in the patent world. So where is the IP protection for that? Because it does seem like there needs to be IP protection for that. So our legislature never really grappled with this issue and make a categorical decision for the country, put it in patents, don't put it in patents, but maybe give it a sui generis IP right, whatever it is. So we have this tension and discomfort with software in the patent world. Now, my view is that software certainly is technological. Sure, by itself it doesn't do anything, but it's never by itself. The whole point of software is to operate computers and machines, and when it does that, it really does magical things that humanity has not been able to do ever before the advent of software. As soon as we recognize that it works on machines, and if the software plus machine combination does practical things that are new and unobvious, in my view is that there should be patents on that. And it would be really good to have clarity on this issue from the courts or the legislature. But the reason I think the situation is fairly dire in the software world is because of this lack of clarity in this space.
So actually I want to go a bit into the practical impact of Alice. I don't think anybody's saying you can't get any more software patents. I think they're saying the practical fact of there not being the clarity that seek is that examiners say there's no clarity and they don't know how to apply Section 101. If you talk to different examiners, they say differently. If you talk to their supervisors, they all have a different opinion about how to apply Section 101. If you go up the chain of the USPTO, I'm sure maybe up to the senior levels, it is similar. Judges are very divided. On the federal circuit, they said they're bitterly divided. Do you think that's an issue? That because of all these things, that sure, you can get a software patent, but because nobody knows how to apply Section 101, you might not get the patent that you deserve. You might not know if you're able to enforce it, and so forth. Does that trouble you, that kind of sense that there's no clarity?
Not for the most part. I should start off by saying I'm all for clarity. If we can make the law clearer law is always better, period. So if we can find a solution on 101 or any other area of patent law that actually clarifies law, that's a good thing. I maybe this is indelicate. Again, come from the antitrust and telecom world, and then kind of encountered IP lawyers on the Hill when I took over that portfolio. I feel like a lot of IP lawyers react to uncertainty different than other lawyers. Right. And granted, I practiced in the real world for all of about 5 seconds before the managing partner suddenly decided that I was not a good, well, it was a mutual decision that was not a good find. And an amicable separation. Sidley is a great firm.
Clause 8 you shared the story, so thank you.
Well, Eli, you've known me for a while, and Andrei, you've known me for, like, big law, it just was not really a great gig for me. It seems like IP attorneys to me have this real problem with uncertainty that I don't see in a lot of other areas, right? When I practice in appellate law, clients would say, are we going to win this case or not? I'd be like, if you knew, you wouldn't have to pay me all this money to handle it for you. I don't know. I'd say it's 60-40, it's 70-30. And those are the odds you get. So part of it is I think there's an overemphasis on certainty as being absolutely essential in the IP world. I guess what I'd say beyond that is that there are federal circuit judges more recently, and you said they're bitterly divided. They've been bitterly divided on specific questions. But I think as a general matter, at least from what I hear from these judges in kind of public settings, some judges are now saying it's not uncertain. It is a kind of a proxy for a technicity test, and it's pretty predictable. So I tend to think things are more predictable than people say anecdotally, or the opinions that are offered up. There's a paper by Professors Datsoff and Rantanen that tested the proposition, are these outcomes of the Federal Circuit truly unpredictable? And they found that, yes, there's some unpredictability, but it is equivalent to or smaller than the unpredictability in most kind of other major patent law doctrines. If you look at the PTO's kind of quality control numbers, 101, according to the PTO and their review of examiner kind of application of 101 is applied in policy, consistent with policy more frequently than 102, 103, and 112. Just from my own personal experience, if I look at a case, a 101 case, and make a prediction before it's decided, I have a pretty good rate of accuracy. I can predict it a good amount of the time, and I'm no genius. I'm not even a patent attorney. If I look at a 103 case or a 112 case and make a prediction, it's a coin flip. To me, it seems pretty predictable, and the numbers seem to suggest that, although I've got a feeling that Andrei is going to disagree with that.
I agree with you that it's more predictable now with the PTO due to the brilliance of the 2019 eligibility guidelines.
That's a discussion that we should have.
But that definitely increased.
Well, can you talk about why you thought that guidance was necessary?
Yeah, well, look, one of the things that patents are not like just any other area of law. The thing, Dave, is that patents are effectively, they're legal instruments, of course, but they're also commercial instruments. So, businesses are made based on the patents, and businesses are made, trying to avoid the patents. All sorts of huge, sometimes super consequential decisions are made based on patent rights by the owners and by the competitors and so on. And in the business world, you definitely need a lot of predictability. And there's no way you could, for example, whether the value of a dollar bill is going to be of 10 years from now, I'm going to flip the coin, and what's it going to be? You have to have a level of predictability I think, in patents that's different from some other areas of law. However, you are right that other areas of patent law are also very difficult and to some extent unpredictable, 102, 103, 103 in particular. But there's a framework. There's a framework in 103 that dates back decades that people know how to apply at the objective level. And we might disagree subjectively how we come out, but objectively, generally speaking, people feel very comfortable with a 103 analysis. And that's really important. I would like to see the survey that, let's do the survey. I mean, like, you have a survey of one. You say that you've reviewed patents as a non-expert, and you feel fairly confident 80% of the time you're going to get it right on 101. Let's do this test. I don't think it's difficult. I think we can take claims from prior cases and give them to X number of practitioners and just simply ask them, is that eligible under 101 and not? and then we'll compare that to the actual decisions that we know have been made.
Actually, there's been some study like that as well, which I guess showed similar results to what Dave is saying, but surprisingly. But is that the target, or should it be the inventors and innovators?
It's inventors, it's innovators, it's their lawyers, and it's the sentiment they have. Do they have the sentiment that they can predict accurately and reliably?
Yeah, and there's also an interesting paper. I don't have the brain to figure out whether it was an accurate methodology, but I think it was a practitioner took an off-the-shelf classifier module, AI classifier module, trained it on claim language, right, and then applied it to new claims that were coming up on 101. And my recollection is he got to, not 100%. You never get to 100%. You got a pretty high level of accuracy. So there's a lot of empirical evidence that it is more predictable than people think it is. And to me, that's an interesting question as to why. And Andrei, something you said actually is very interesting to me, because I look at 103 and I agree completely with you. It's a very clear kind of framework for deciding this. But in any given case, I don't know a patent attorney that can give me a clear answer whether I'm going to win or whether I'm going to lose. And it seems to me that should be really important, like that level of uncertainty. That's the difference between my patent being valid and invalid, assertable and not assertable. And it's the same difference in 101. And I'd say, roughly the same level of uncertainty. And people flip out over 101 and 103. As you said, they're completely fine with it. And to me, that seems illogical.
Yeah, look, if we did a study at the PTO on 101 and examiner consistency. Hard to do this study, but we had our chief economist do the study, and the uncertainty of decision of 101 decisions was very high pre-2019 guidelines from examiner to examiner in the same art unit. And that really improved after the 2019 guidelines when you had a clear methodological, objectively understandable system through which to put the analysis. That's the issue. Sure, again, subjectively, people might come to different results. But at scale, when we're talking globally, as long as we have a methodology, and that's why the 2019 guidelines work so well, not because we changed the law, it's because we created a methodology where the 9,000 examiners can apply it in a systematic way and just ask practitioners. First of all, we have the data from the PTO that the certainty of decision increased dramatically within the office, but then also ask practitioners. They will tell you that for 101 and 103 at the office, they're equally satisfied now by and large. Not so with the courts. And here's one of the clearest examples of what the queasiness, the feeling that is given to us from the courts. We have decisions from the Supreme Court in escrow accounts, in hedging transactions, okay? Alice Bilski. We have them in natural phenomena and in the BRCA2 gene, in Mayo and Myriad. And all of a sudden, the Federal Circuit tells us that an automobile axle, it's not a hedge fund, it's not, it's not a phenomena that is observable like the BRCA2, like the BRCA genes. It's not an escrow account, like an automobile axle. So people are like, all of a sudden, wait a minute, that came out of left field. And there are other examples like that you hear practitioners complaining about, garage door openers, because there is no objective methodology. Every now and then you get these random results that throws everybody off.
Are you troubled by those types of decisions?
No, but I was going to pay Andrei a rare compliment here. If you look back at the comments that I've drafted to the PTO, Andrei's guidelines, I have one big substantive issue, which we don't really need to get into. They were largely very positive, and we thought they would increase consistency. They did. I can't remember what the report, adjusting to Alice or something, that the Office of the Chief Economist did. But again, when you look at that, it seems like there's not just predictability. Consistency and predictability are related but slightly different. But the data suggests that there is significant predictability, there is significant consistency, yet I routinely hear prosecutors complain and say, it's no better than a coin flip. I don't know what happens at the office. And I look at this, I say, I don't understand how anecdotally every prosecutor I know thinks this is a disaster. But when you aggregate all those experiences into like higher level data, it looks exceptionally consistent and exceptionally predictable. And I also note in the adjusting to Alice, at least at that time, the rejections were also by and large lower. There was a lower rejection rate on 101 than pre-Alice, which suggests that this is not an Armageddon, end of the world type of event.
Very interesting. So you're right. After the guidelines, again, we didn't change the law. Administration cannot do it, just grouped the cases into categories, made it easier for 9,000 examiners, many of whom don't have law degrees, to apply this thing in a systematic method. That alone reduced the percentage of rejections under 101 to pre-Alice levels. So to me, that's the key. An objective, predictable, organized method.
Well, I want to go back to those two cases that Andrei brought up.
You want to talk about American Axle?
No, I didn't go to lines, but do those, when you hear about decisions like that, are you like, all right, well, courts get things wrong once in a while? Or do you understand that the issue with like the garage door opening being not patent eligible under 101?
Chamberlain and American Axle. So they don't trouble me all that much. And I think they don't trouble me for the same reason that Sequenom didn't trouble me. I look at those claims, and again, I'm not a patent attorney, so what do I know? I look at those claims, and they look like bad claims to me, right? Where they have tried to claim an abstract idea through the addition of some kind of physical structure, physical limitations. And I think that is actually the hardest aspect of the law to figure out. And it's not like the United States is the only one who's had trouble figuring this out. This has been an issue over and over again in other countries as well, because it's genuinely hard. What do you do when you claim some physical structure that's generic at a high level, and you claim that in conjunction with an abstract idea? And I guess my best answer is, it seems to me it's got to be a spectrum. At some point, the abstract idea is sufficiently integrated into whatever the physical structure is, whether that be a general purpose computer or some other type of machine, that it crosses over into eligibility and is no longer an abstract idea. But that's inherently a very difficult question, and it's inherently going to be subjective. I mean, that's the problem, I think, with the desire for like kind of bright line rules here is that's not a question, I don't think. Well, you can answer it in really bad bright line rules. You could say they're all in or they're all out, both of which are bad results. Right? They're bad options. To do anything beyond that, you are going to have a rule that is somewhat subjective, and people in the patent community don't like being told that, but I think that's inevitable because it seems to me it's an impossible question to answer in a completely objective, non-subjective way.
So before we discuss the path forward, I want to just highlight one statistic that I recently discovered, that the tag group in the USPTO that examines applications related to AI includes a 101 rejection in 77% of all office actions. We discussed there might be some disagreement about whether software is technical, but I think if you ask the average layperson, is artificial intelligence technical? It requires huge investments in research and development. Does that statistic trouble you? The fact that somebody's filing a patent application that they think is related to artificial intelligence, in their minds it must be technological, and here they are stuck with a 101
I saw
rejection.
your article on this, and it intrigued me. I have been quite busy, so I meant to follow up on that. I have not yet had a chance to really dig into the data. It does not necessarily trouble me. And that, again, I think there is a tendency to want to put things into neat little boxes. When I see what people call AI patents, there are foundational AI patents of which I'm aware, and they don't look like AI patents. They look like software patents. They're detailed. They're usually about some methodology for training the AI. These things are foundational. They're technical. They're, I would think, in innovation, extremely valuable. And then I see people saying, well, here's an AI patent, and it's a method for selling dog food on the internet using AI, right? And it has to do with dog food marketing. Has nothing to do with AI other than it mentions, somewhere servers, and somewhere deep in it says, and you, by the way, use AI. But there's no disclosure about how you use the AI. There's not even a purported innovation in the AI. The innovation is this wonderful new method they think they've come up with for marketing dog food on the internet, right? And those to me are not AI patents. And so, no, it doesn't, like, on its face, it does not concern me. 77, though, is a high number, so I'm going to look into it, but it's, on its face, it's not a huge problem.
Well, the concern is if the number is that high on a consistent basis, that means there's a disconnect between the applicants and their lawyers versus what the office is doing, right? Because otherwise, the lawyers will adjust. There's some disconnect there. What's the art unit in this study? Do you know?
I think it was the 2100s. But, I mean, for example, the business methods, they've been consistently very high. So I don't think those lawyers have adjusted.
Appropriately high, I think you meant to say.
But I'm saying they didn't adjust in terms of not getting
So look, I would also need to see the study and exactly...
2120, working group 2120.
Okay.
AI and simulation modeling.
Okay, so, I need to know more about the study, but frankly, I'm not shocked. A lot of these innovations deal with mathematical formulas and mathematical algorithms, heavy math. Under the guidelines, that's automatically a trigger into the 101 analysis. So if you see mathematical formula within the claim, now pursuant to the guidelines, you have to go to the next step and see, because math per se on its own, as we said, is not eligible. So now we have to see if it's integrated into a practical application. Does it do anything practical? I'm not shocked that at least on a first office action, which I think is what you said, you get a lot of these rejections. So I think it will eventually settle down, those statistics. I do think when it comes to AI, the office needs to do a significantly better job giving guidance to the public and to the examiners. First, it needs to be better at saying what exactly it means, what the office means by AI. So far, it hasn't said anything, yet it put out guidelines that are currently enforceable on how to treat certain aspects of AI patents without defining what AI really is. But then I think the office would be well served to add a significant number of examples to the MPP of various types of AI applications and how to treat them under Section 101. I think that would be very helpful to do sooner than later because the technology is upon us now.
Yeah, I think there's one example. Yeah, I think there's one example.
And it's important to note, too, if you look back at history, I mean, there was a point, I can't remember what the exact number was, but there was a point at which something like half of the pending applications of the Patent Office had to do with improvements on the bicycle. Right now, AI is the flavor of the month, year, decade, however long it's going to last, just like the internet was the flavor of the month for, in whatever the 1990s, and personal computing and software was in the 80s. And you get this flood of patents that are trying to hook onto that trend. Yeah. Right. And quite often, as I said, they don't have anything to do with innovation in software or computers or AI themselves. They have to do with typically applications of software patents. And when nothing is explained, when there's nothing novel about the technology, you could imagine that it would be entirely appropriate for there to be a low allowance rate. Although, again, I want to dig in the details because 77%. I mean, that's anything over 50%. I'm intrigued. I want to see what. I found the data later. You're gonna have to walk me through the methodology because for people who necessarily have technical degrees, I will say that patent academics and patent attorneys, I'm terrible at math, and I look at the methodology. I took some risk
that I was clicking the wrong buttons, but I put the data out there.
Okay, so I will review it.
So I actually heard way more agreement today than I expected. And you said you would prefer clarity. Dave, you said you'd prefer clarity in Section 101 if possible. What would your be compromised, through legislation that you think would be reasonable to get more clarity on Section 101?
Whatever the opposite of PARA is. I mean, because not to be mean, but having reviewed, again, a lot of these bills in a lot of different countries, I'm terrified by PARA. But we can discuss that more specifically. I guess for me, so the system, to me, that seems to have worked the best that I've actually observed is the kind of EPO formulation. And you mentioned like technical problem, technical solution. or technical solution to a technical problem. That's a piece of it. I think the two pieces that are essential from a policy perspective, and then there's a question of how you implement them. I think Andrei is 100% right. The difficulty of training 9,000 examiners who are mostly not attorneys on this stuff matters. That is something that we should be thinking about. From a policy perspective, I think you really only need two pieces. You need a technicity requirement, and that's technical character in Europe. Is it a technical problem, technical solution? They have other aspects like formulations. Is it something that people with technical training do? Is it in an actual field of technology? That's the one piece. The second piece is ensuring that patents reflect an advance in an area of technology, in a field of technology. If you can do those two things, then I think we've got something that we can actually talk about in a sensible way.
And is advance something separate from obviousness?
No, not to me. I mean, the way that it is. I'm about 5 or 10 years out of date with Europe because I no longer do international. But at least when I did interact with the EPO, the way it was being done was you only consider the technical features of the invention when assessing obviousness. And you could do something very similar here. Say, okay, we're going to separate these features into technical, non-technical, and you have to show technical advance. So we're going to assess non-obviousness based only on the technological features.
Does that sound good to you?
No. Only because it conflates the various concepts of the patent code. One of the brilliant bills in the whole history of American patent law was the Patent Code of 1952, and its brilliance comes from separating the various areas of invalidity. It separated 102 from 103, added 112, and 101 being all separate requirements. And I think the courts right now, the lower courts right now, are conflating those. And I think your proposal, Dave, further would make it even more confusing and take us to a place pre-1952.
Well, just to be clear, I am largely agnostic as to whether you do it. I don't have the same kind of level of concern, but I do like nice, neat, clear doctrines. So I'm kind of ambivalent as to whether it goes into 101 or 103. And I think it worked perfectly well in 103 if people are more comfortable with it happening there. And if you look at the kind of European system, they went through an interesting evolution where they initially did it as their version of 101. It is part of patent eligibility. And then at some point they said basically exactly what you said. This doesn't make sense. We're borrowing from these other doctrines, and they moved it into their version of the obviousness test.
I mean, what about just technological solution to a technological problem?
That's the bill. I mean, you're going to have decades of litigation as to what that means, and how is it different from obviousness, for example, and the like. Let me just back up for a second. So first of all, we already have statutes that deal with the concept of newness, an advancement, as you say, Dave. Are you really making an advancement in technology? 102 and 103 deal with that. We already have statutes dealing with specificity. Is it purely an abstract idea, or is it specifically defined in a non-result-oriented way? That's 112. A lot of the rejections under 101, especially in the courts nowadays, are rejections because the claims are result-oriented and don't have enough specificity in the methodology outlined in the claim. Fine, but that's a 112 rejection. Or it's conventional technology. That's another form of rejection under 101. Fine, but that might reject the claim, but do it methodologically under 102 or 103. 101 is for something else. 101 is simply the threshold question whether you're in the patent system or not in the patent system. It's the thing that we discussed at the top of the podcast. Every country has this. So let's not forget that, because you bring up, Dave, the European system. Look at Article 52 in Europe. And all the major jurisdictions have the same methodology. Article 52, paragraph 1, basically says a bunch of words, but then it has to involve an inventive step and are susceptible to industrial application. Susceptible to industrial application. Okay? That's what tells you in that system what is generally in. For us, it's the useful arts. It's, method, machine manufacture, composition of matter. It's a broad statement of what's in. Then if you look at Article 50, European Patent Code, Article 52, Paragraph 2, it outlines 4 things that are out, right? The following, in particular, should not be regarded as inventions within the meaning of Paragraph 1, and it tells you 4 things. Discoveries, theories, and mathematical methods, that's 1. 2 is aesthetic creations. 3 is schemes and rules and methods of performing mental acts, and so on, more words. And then D is presentations of information. That is, and all of those are excluded when presented as such on their own. Okay? And the other major jurisdictions have the same formula. So you have broad statement of what's in, an explicit statement of what's out. Then, after that, the third step is trying to figure out how to resolve the confluence of what's in and what's out. When you have mixed claims, all jurisdictions have this. And if you look at the 2019 guidelines from the PTO, that's precisely what it does. The what's in is already provided by Section 101.
And is that a description of PARA as well?
So that's generally what PARA tries to do. Now, it's more difficult to do it in a statute, but it's absolutely doable. Dave will disagree that you don't like the stuff that's in or out in PARA. There's other things you quibble with there. But what I always say about that is you have to have a national debate to agree. I think generally everybody agrees on the broad statement. And PARA doesn't modify the broad statement. Method manufacture
modifies a little bit, but yes, you're generally right.
The generally categories are still there from 1793. The crux to PARA are the specific exclusions that are outlined in the statute and says no others, these are the exclusions. And you don't like those. You'd like some more exclusions. I imagine there are other people that don't like that there's too many exclusions. And you have found, Dave, some strange bedfellows in not liking it because they're not enough for you and there's too many for them. But that's what Congress is meant to do. That's not for the courts. We talked about diagnostic techniques. They're out in today's world. Courts decided that. Why? This is a major issue for the American economy. The legislature needs to debate that. And whatever it is, it is. Make a decision, put it in the statute, and now we will all know. Aesthetic creations, it's in Europe. Here in the United States, that's not out right now.
Should be.
You think it should be?
I do.
I disagree. And but that's fine. Let's have the national debate, have Congress decide that. And whatever the decision is, it will be in the statute. And now we will know.
Let me jump in. I think they're kind of moving away from my quibbles, as you call them. I'd say there may be more serious disagreements than quibbles. But I think there are 2 fundamental things, one about the European system, one about the U.S. system. One thing that's important to realize about the European system is from all those specific exclusions, they inferred a general technicity requirement. So they actually, through a kind of, which is strange because it's much more statutory than common law, through a common law approach, at least in the EPO and large boards of appeal, they moved towards a general technicity rule, which is where I would like to see us land. So yes, they do have the specific exclusion. Totally, I agree with almost everything you said. But we have to remember that, in my view at least, what makes the European system work well is they have inferred from those specific exclusions a more general principle of requirement of technicity. The other one, and this is a big issue for me, and I don't understand. I think you're willing to discuss it because we've had some background discussions. Most people aren't even willing to discuss, even entertain this. But there is a tie between 101, 102, and 103. So take the printed matter doctrine, right? So the notion that you cannot patent novel information that is embodied in some sort of manufacture. Even though it's a manufacture, and manufacturers are patent eligible under 101, there's case law out there that says this is outside the scope of 101. It is normally applied in 103, and this is responding to Andrei's totally correct point is we have 102 and 103 and 112 to do these other things, but they're affected by 101, right? So now printed matter is almost always, not always, but usually applied through 103, where you don't give any patentable weight to the novel information, right? And why is that? Well, if you look at the case law, it says that's because it's excluded under 101. So these arguments can't happen, or discussions or debates, they can't happen in a vacuum. What we do on 101 directly affects how the 102 test is going to apply. So if you just read para, for example, if you look at it and say, okay, is a sculpture, which is an aesthetic creation, patent eligible and patentable under para? Well, it is a manufacture. It doesn't fall within any of the exclusions. And then you get to a real problem, because then you're going to go to 102 and 103. And because aesthetics are not excluded under 101, you are literally going to have, at least if they follow the structure of the 52 Act, and I agree it was generally good structure, good methodology, they're going to have to start considering whether a sculpture is aesthetically non-obvious over prior sculptures. Something that, I don't know why sculptures would ever be patent eligible or patentable, but B, something that the PTO is...
How about we exclude sculpture from that?
No, because it's a general principle. I don't want, I know people love Taylor Swift and she's wonderful. I don't want the next Taylor Swift song to be patent eligible just because it's recorded on a CD or on an LP. I don't think that's appropriate for the patent system. And the people who say, 102, 103, and 112 will take care of it, it's the opposite. Once you include it, once it's no longer excluded under 101, once it's explicitly included, then you do have to do that analysis under 102 and 103. I think it's inevitable.
Well, hold on a second. So, not to jeopardize our violent agreement for the whole hour here, but I'm not sure I've heard your sculpture example before. This is a new one. But wait a minute. A sculpture, you mean like out of marble or out of bronze or something?
So somebody gets a big piece of stone and they hack away at it and it turns into something beautiful.
That is, from the very beginning of time to today, is absolutely patent eligible. It's a manufacture. It's a product. It's a useful thing. But what's new about it? It's a piece of rock, right? So what's the novelty of the piece of rock? Or what's the non-obviousness of that piece of rock if that's the sculpture made of? And there's no question, I don't think anybody would say that the new shape the artist puts in that rock has any patentable weight. I don't think you can get a patent in today's world for a marble sculpture, but not because of 101, Dave. Look, my only point to all of that is have the national debate and have the legislature decide one way or the other. Because on all of these points, aesthetic creations, you want them in or you want them out. It's an important decision for the country. The Europeans decided to keep it out. So far here it's in. Have the debate and then make a decision. Same thing for information, okay? Which you're right, that currently there is no patent protection on information itself per se, as such, or data. I've said publicly that I think the country in today's information age needs to have potentially a sui generis new type of IP protection of some sort on the data sets themselves. It's a different conversation. But right now, it's not in. If you don't think PARA has that data itself as such out, and you're concerned that as a result of that, it's because it's not listed, it should be in, make that amendment, put it in, and let's have the national debate, see what the legislature wants to do. That's my only point.
If they're willing to give me the pen so I'll just say I've been making this point for 4 years and the bill hasn't changed. So I agree it's a great thing to debate. You give me the pen, let me write, and then we can debate my bill. Yeah. Then that might actually work because we'd actually have that debate. So far, it has not worked.
When you elect me to the Senate,
you'll hire me as your IP counsel.
You will have an open. You will have an open door to.
So actually, that's actually my last question, I guess. Way forward, you say we should have a national debate, and I'm not sure you'll ever have a true national debate on Section 101. But at least those interested in patent issues have been having this debate for at least 10 years. And whatever bill comes out, people on the other side always say, come up with some new clever example, which they use to convince everybody that this is horrible. Andrei, how do we get to a point where the other side, who doesn't really want or need any changes, When is Dave
You're
going to say,
asking me
let's
with
do
Dave
this?
in the room what Dave is going to do and when and how?
Yeah.
He should tell us. I don't want to speak for... I mean, I will very happily speak about what Dave will do when he's not here. But look, I think it is important for the various sides to come together and actually not posture and have serious working sessions and present the concepts and be willing to engage in the process and say, look, somebody might say, I want aesthetic creations in. Somebody might say, I want aesthetic creations out. Put it in, have that conversation, okay? And then have a vote. And then it will be one way or the other, and then we can all move on in life. What's not acceptable in my mind is to just completely block the progress of needed legislation and just maintain the status quo. This issue is actually really hard, but the statute hasn't changed since 1793. It just simply cannot be that we can be a competitive nation with technologies of the 21st century when we are relying on a statute that was written in the 18th century. The legislation needs to come and do its job and pick up the mantle, have the discussion, and if the other side doesn't want to debate, well, then they're not going to be at the table, and then the debate will happen without them, but it has to happen.
Dave, what will it take for you to sit down and come to an agreement about?
I don't know if we'll ever come to an agreement, honestly. But let me say this. So I have a very different perspective as to this process. So let me recount. So we had an initial round of kind of roundtables and hearings, and HDIA proposed specific language. The staff at the time liked that language, and some of it had to do with amendments to 112. We got partway down the road, and the other side really didn't like where it was going, and so the process ended. And we restarted the process in a place more favorable to the other side, which, kind of a process foul, but we were willing to live with it. We went through a whole nother process. And we're talking about a 6-year period now. And I want to make clear, I am not blaming Andrei. He's not been a thorn in my side, as you can tell. We actually get along and agree on a lot of this. But just in general, so this generic other side, we start this over again. And a bill is introduced that it's 95% the other side's language and has one small concession to me. So it's not great. We oppose the bill, but at least there was a little bit of balance. The bill between Congress, the last Congress and this Congress, was rewritten to remove that one tiny concession and is now only the language of the other side, after which it was announced that they were going to go to markup without any changes. Right. So at least and I'm sure the truth is somewhere in the middle. Right. I experience things one way. Sometimes Andrei experiences them another way. And I'm trying to cast a little blame and a little shade. But that's not my main purpose here. I mean, generally, I admit that I probably have a stark view of the world that my perception is in part dictated by where I sit. It's what I see. But that to me is the opposite of what Andrei is talking about. We were not the ones that walked away from the table. At the beginning of this Congress, I said we should carry on having large meetings where we actually debate principles. And the answer was we are not. And again, not Andrei. It was, we are not interested in doing that anymore. We want what we want, and that's what we're taking to markup. And that isn't a national debate. And that isn't like tech stonewalling things. And I think if you went back and talked to like Brad Watts, I made a commitment up front to him. I would act in good faith. I would actually discuss these things at a principled level. We stuck through it. We spent hundreds of hours producing documents. And then at the end, what we got out of it was a bill that was exactly what the other side wanted, where none of the stuff we proposed was incorporated. And that to me is just not the way to get to a bill. And so now we're in I think if we're talking about the way forward, a really difficult tactical posture, right? Because you have one side now that assumes the goal is to just jam through the most aggressive bill possible over their objection. And if that seems like the goal of the process, you're never going to get people roughly on my side, especially in the life sciences where they want to bill much less than I want to bill, to come to the table. There just won't be the discussion. So I don't know. I feel bad just criticizing and not offering a solution, but I actually don't know what the solution to that is, because if you don't trust the process, and usually the threat is, what Andrei said is, well, if you don't come to the table, we'll just jam the aggressive bill through. Well, that's what happened from our perspective when we did come to the table, so now it's no longer a threat. And that's, I think, not a good place for either side, right? And that's part of the reason I agreed to do this with Andrei, because I think this is actually, give Andrei a second compliment, begrudging compliment, Andrei. I think this is like one of the most substantive and useful 101 conversations I've had in 6 years. And it shouldn't be that way. We should be having these kind of substantive, civil, reasoned discussions as attorneys about the legislation. And I have just not found that to be the case.
Just very quickly, since I have Dave here, I'm going to make a final proposal. The bill is the following, the new 101 bill proposal. This is it. We shall adopt the PTO's 2019 guidelines as an amendment to current Section 101. Agree?
No, I'm afraid not, Andrei.
Is that a better starting point than?
Yeah, I'd say that's a better starting point. I think that was much clearer. I think I have a problem with you're integrated into a practical application that's an end run around Alice Step 2, which might work fine. Doesn't really, I think, work for people on my side. But as a starting point for discussion, yeah, that may make sense. And this is actually important stuff. I mean, 101 has, as I said before, implications for 102 and 103. It has implications on its own. And I think it deserves a more substantive conversation than what we have had to date.
I agree that this has been a fantastic conversation on 101. Thanks, Dave, for engaging. I'm willing to do this anytime. And Eli, for giving us the opportunity.
Thank you.
Yes, thank
you,
Eli.
Clause 8.
Yeah.
Thank you so much for listening to Clause 8. New episodes come out every 2 weeks, so be sure not to miss them by subscribing at clause8podcast.com or wherever you listen.